So one of the emails we got, one of the questions we received was, can I file a domestic violence lawsuit against my abuser? And the short answer is yes. As a victim of domestic violence or domestic abuse, you have a couple of avenues and several ways how you can handle that situation. You can file a civil order of protection, or you can go to the police department and you can file a criminal complaint. In the state of Illinois, vast majority criminal complaints will be accompanied by a criminal order of protection. So once you file a criminal complaint and your abuser gets arrested, more often than not, court will automatically issue an order of protection, which is connected to the criminal case, that being criminal order of protection, criminal proceeding. But let's break it down. If you do not want your abuser, your spouse, your girlfriend be arrested, you do not want to go down the route of lengthy court proceedings and possible enjailment or incarceration for your spouse or your girlfriend, you always have the option of going to court and filing a civil order of protection. It can be no contact, no stalking. There are several options, several different avenues individual can take. By filing that complaint, by filing that civil order of protection, you give yourself a possibility to live a normal, healthy life without the abuser coming near you, going to your home, going to your place of worship, having the abuser contact you through a third party, through social media. You simply are getting protection from court that states that you have the right to live your life in a way that you deem fit. And your abuser cannot violate certain terms of that order of protection, cannot come within, let's say, 500 feet of you, and cannot contact you at work. That's the fastest, easiest way to put somebody in their place should they violate your personal space and liberty, so to speak. More complex way, more challenging and more difficult way to teach your abuser a lesson or explain to your abuser that whatever was done to you is improper is to call the police and contact the police department. But in that case, you have to make sure that violations of your civil liberties have actually been violated, that your liberty, your well-being was taken advantage of by your abuser. It can be done mentally, it can be done physically. So let's say you get into an argument with your wife and your wife throws a fork at you and that fork then scratches your face or breaks your skin. Police, upon investigating that specific incident, can arrest your wife or your girlfriend or your husband, whatever your marital situation is at that moment, and they can place an individual under arrest for domestic battery. Now, in Illinois, the crime of domestic battery is a non-bondable offense, meaning that individual will not be able to bond out at the police station. They would actually have to go to court. They would have to go through the bond process and be at the liberty and mercy of the court and that specific judge, who will decide when you can leave and what restrictions will be placed upon you by that court. More often than not, it's either GPS monitoring, electronic monitoring, or a substantial monetary bond. Usually, that bond is also accommodated by a 72-hour stay-away order, meaning that individual cannot go back to the place where the incident happened for the next 3 days. In addition to that, a criminal order of protection will be filed against that specific individual who engaged in the criminal act of domestic battery. The court proceedings themselves will take a substantial amount of time to resolve, because one cannot receive order of court supervision for the crime of domestic battery. The court has only two options, either to convict that person on paper or to actually incarcerate them. Convicting somebody on paper, it means you have a conviction in your background. you will have a conviction for a misdemeanor offense, assuming there are no significant damages done to your well-being and your body. No aggravating factors have been involved, such as somebody is over the age of 65 or there are no fractured skulls. The court will have only two options: convicting you or incarcerating you. Generally, domestic battery is considered to be misdemeanor, meaning punishable by up to 1 year in prison. Actually, strike that. Domestic battery is a misdemeanor, meaning it can only be punished by up to 1 year in jail. Under certain circumstances, domestic battery can become felony, which means it will be punishable by 1 year in prison and up. Once individual is being charged with domestic battery, it's absolutely crucial to retain an attorney who knows how to fight that specific charge, because it's necessary for vast majority of people to be able to avoid convictions from misdemeanor charges or felony charges. Crime of domestic battery can have several ways how it can be resolved. Everything from charges being dropped, dismissed, individual receiving deferred prosecution, meaning anger management classes, community service, perhaps alcohol and drug evaluation, something the court would be satisfied with that the individual has in fact learned their lesson and they will not be engaging in similar activities in the future. The crime of domestic battery can be reduced down to simple battery. And simple battery in Illinois is offense for which one can receive order of court supervision. Supervision by definition is not a conviction. So for vast majority of people, they will be able to go about their normal daily lives, get jobs, go to school, apply for professional licenses, because they will not have a conviction on their background. So that being said, once somebody is charged with domestic battery, it's crucial to not give in, not get discouraged. Those cases have to be fought in court. Those cases can be resolved, and those cases can be resolved in your favor.